Hi everyone and welcome to Housing News with Amy C3. Thank you so much for being here. We have a lot to cover, so I'm going to go ahead and get right into it. The Alabama Realtors Association has resubmitted its request for the Supreme Court to lift the CDC's moratorium on evictions that went into effect on August 3rd. The new moratorium is limited to areas with high COVID-19 transmission rates, covering 90% of affected tenants who are behind on payments. Various members of the political class continue to openly question the legality of the CDC's unilateral decisions over the federal ban on evictions, which, mind you, was originally enacted under Trump's direction last September. In August 2020, Donald Trump wrote an executive order instructing the CDC to consider whether any measure temporarily halting residential evictions for failure to pay rent is reasonably necessary to prevent the further spread of COVID-19. Under Title 42, Chapter 6 of the United States Code, the Public Health Service Act established that the Secretary of Health and Human Services had the authority to enforce quarantine measures. This is for preventing the introduction, transmission, and spread of communicable diseases across the United States or from foreign countries. A Title 42 appointment extends quarantine authority to specialized experts without regard to the civil services laws, and this is where the authority was delegated to the Centers for Disease Control and Prevention. Under U.S. Code 70, the CDC already had the authority to enforce measures in the event of inadequate local control, if events or measures taken by states or territories are insufficiently preventing the spread of any communicable diseases, and additional actions to prevent further spreading is deemed reasonably necessary. This, of course, led to the CDC issuing a nationwide moratorium on evictions September 4th, 2020. Congress had already delegated unilateral authority to the Secretary of Health and Human Services for making public health decisions mitigating the impact of communicable diseases like COVID-19. This power was a simple handoff from the Secretary to the CDC, who determined that the moratorium met the reasonably necessary measure test posed by the Trump administration. Based on my observations, the landlord lobby, including the plaintiffs in Alabama and Georgia Realtors Associations, is challenging how the federal government derived its authority for isolation and quarantine from the Commerce Clause of the U.S. Constitution. The American Bar Association makes clear that, through the Commerce Clause, which gives Congress exclusive authority to regulate interstate and foreign commerce, the federal government has broad authority to quarantine and impose other health measures, although that has never been affirmed by the courts. Congress did end up extending the moratorium from its original deadline at the end of 2020 to January 31st in the 2021's Appropriations Act, but all of the 2021 extensions after were authorized through the CDC. In the Alabama Realtors case, the D.C. District Court originally dismissed the government's argument that Congress had ratified the CDC's authority to ban evictions after January 31st, noting the legislation did not expressly approve of the agency's interpretation of Article 42, but merely extended the moratorium during Trump's lame duck session. The court also challenged the government's interpretation of 42, authorizing a financial penalty of up to $25,000 if landlords did not comply with the moratorium, making the fair assumption that without these provisions, landlords would try to evict their tenants anyway. These judgments rest on a technicality that congressional authorization wasn't explicitly stated in COVID-19 legislation, even though the precedent for this transfer of power had been well established. The district court ultimately held their injunction to vacate the ban by employing the sliding scale approach, requiring that the government need only raise a serious legal question if the other factors strongly favoring an issue to stay, and other factors strongly favoring an issue to stay would be the deadly pandemic that has already caused millions of people to die or experience eviction already. Other factors strongly favor those on top of other public health risks, and putting the lives of tenants above landlord profits is the reason why both lower courts ultimately decided to hold on that injunction. But this didn't stop the plaintiffs from appealing the DC Circuit Court, which ultimately reached the same conclusion to pause the moratorium lifting. All gas, no brakes, though, for the Alabama Realtors Association, who submitted a request for the Supreme Court to lift the CDC order on June 2nd. While the application was pending, the CDC announced their final extension of the moratorium until July 31st, prompting plaintiff counsel to urge the Supreme Court to hear this case before the order was finalized. On July 29th, the Supreme Court ruled in a 5-4 decision to not lift the eviction ban. In a shocking twist, Brett Kavanaugh deviated from the conservatives' otherwise unanimous decision to let the moratorium expire June 30th, writing in his non-binding opinion that the CDC exceeded its statutory authority with the nationwide moratorium.
Yeah, well, that's just like your opinion, man.
He also acknowledged that the moratorium was going to officially expire at the end of July anyway, which would give Congress enough time to craft clear and specific legislation, which, in his non-binding opinion, would be necessary for the CDC to extend the moratorium past July. Unfortunately, Congress did not authorize new parameters for the CDC through legislation, which means that if the Supreme Court reconvenes, the conservative majority will likely strike down the eviction ban for good. Let's take this case to data and see what a premature lifting on this moratorium will look like. Accepting the results of the UCLA study recently published in the Journal of Epidemiology, while areas that are lifting prematurely during a 4-month period resulted in double the rate of cases and 5 times the number of COVID deaths after the moratorias were lifted. Applying these calculations to the New York Times database tracking allows us to project the potential increase in average cases and deaths tied to COVID-19. Eviction risks and vaccine rates would need to be controlled for a more accurate projection, but these are the numbers leaning towards the worst case scenario. What is most shocking is that we are seeing a lot of hypothetical L's right now for the renters. Not a lot of protections exist for tenants anyway, and that this is still up for debate as to whether or not there was a legal avenue for Joe Biden to put pressure on the CDC to extend the moratorium. While looking at the number of possible deaths and possible cases, it's pretty clear that at the end of the day, tenants would be taking the L, and too many hypothetical L's right now for the renters. So let's move into our final story that breaks down how there could be a win on the horizon for tenants in Washington, D.C. I'm going to go over an article from Reuters that breaks down litigation that could establish a model for tenants to enforce their fundamental housing rights amid a spiraling housing affordability crisis predating COVID-19 that disproportionately harms Black and Latino renters more than any other group in the nation's capital. The lawsuit alleges that landlords waged a years-long obstruction campaign against tenants of the Park 7 community who formed a tenant union to protest deteriorating housing conditions that the city police department aided property owners in illegally suppressing tenant rights. The group claims problems at the complex included water leaks, mold, pest infestation, insufficient security. The complex previously reached in a settlement with the city attorney general to refund nearly $500,000 to tenants who were improperly charged for water use that was falsely marketed as included in rents. Management has prevented the Park 7 residents from organizing by calling police, denying access to common areas, and intentionally disrupting residential meetings. According to the complaint, which also says management threatened union members and leaders with unlawful evictions, removed flyers from public spaces. That lawsuit was filed under the District's Right of Tenants to Organize Act, enacted in 2006, giving tenants and rent organizers the right to self-organize and advocate to address how improving their lives and living conditions would be to benefit them collectively as a union. Owners can't interfere with most self-organizing activities, including meetings, canvassing, and distributing literature in common areas at the tenant's door. And something that allows tenants in DC to have a bit more protections is the fact that the District of Columbia grants tenants whose landlords decide to sell the property and broadest set of rights, including first rights of refusal, which means that tenants would be offered the home before it would go onto the market if the owner was planning to sell. So this is an absolute win for the tenants in DC. They do have what could be the most tenant rights afforded to them, and by hearing this case, this would allow for the first precedent to be set to build the statutes that would then apply for renters who would move forward with litigation thereafter. The reason why this is so incredibly important to set this precedent is because no tenant has exercised their rights over their protections as renters thus far. So this could amount to a huge win for the tenants. I wish them all the best, and I'm looking forward to keep up with this case to see how the story unfolds. That being said, this has been Housing News with Amy C3. Thank you so much for joining in, and we'll see you next time.